Welcome to the Daughter Arise channel. My name is Yvonne, and this channel is all about bringing you content about childhood sexual abuse. I am a survivor of abuse, and on this channel, I share things to do with my experiences, things that I found helpful, hopeful, things that I found difficult in hopes of empowering and encouraging other survivors. I also share news stories on this channel and add my thoughts and commentary to these stories. And also as well, I do interview other survivors and their supporters in hopes of raising awareness and educating on this subject of childhood sexual abuse. So if this is the type of content you're looking for, please hit the subscribe button and the notification bell so that you can be notified of any new uploads. And if you like the content, don't forget to hit the thumbs up button. So I want to introduce you to Malcolm Johnson. He is a solicitor who specialises in child abuse compensation claims, and he is one of the leaders in the field, as well as being a founder member of the Association of Child Abuse Lawyers, an organisation set up to help survivors of abuse. He is a fellow of the Association of Personal Injury Lawyers, a member of the Law Society's Personal Injury Panel, and the secretary of APIL's Child Injury Group. He is co-author of a definitive textbook in this area, Child Abuse Compensation Claims, published by Jordans in 2011. So the reason I've invited Malcolm on is because a lot of survivors have asked me over the years questions to do with child sexual abuse compensation. I have myself very little knowledge about this. So this is why I wanted to invite Malcolm on so I could ask him some questions around this. And hopefully in doing this interview, it will answer a lot of your questions as well. So welcome, Malcolm, to the Daughter Arise channel.
Hello there. Hi. Thanks very much indeed.
So before we get into the questions about child abuse compensation, can you tell me a little bit about your background, how long you've been practicing law?
I've been a solicitor since around 1994. Just to correct one thing that you said, Yvonne, and that was that I was the secretary of the Child Injury Group of APIL, but I'm no longer, basically. But everything else that you said about me is absolutely correct.
Okay.
So I think that was from an old lecture that I had done, basically.
Okay.
Yes, I've been practicing law now since 1990, pretty much 1994. Yes.
Okay. And what made you specifically getting into law to do with child abuse compensation? How did that come about, and how did you get into it?
I was working in a firm in Islington, as I recall, and this must have been around about 1994, 1995, and a number of cases came through our door. I was a personal injury lawyer. I did personal injury law, but I was approached by a gentleman who was involved in a criminal trial. This was one of the first big trials, big prosecutions against abusers, and he had been in a children's home in the late 60s, and I took on his case. He was part of a group action, but I took on his case, and it took a bit of time, but eventually we managed to get him compensation. But that was the first case that I did. And the thing that I remember very clearly to this day is that when I looked at his statement, this was his criminal statement given to the police, I still remember where I was at that particular time. I was just struck by how serious this was. And this was something quite unlike anything I'd ever seen before. So I took on his case. And I think from pretty much that moment on, I decided that this was the type of case that I would like to do. I've done other types of personal injury claim, and I've done some clinical negligence in my time, but I now specialise pretty much exclusively in child abuse compensation claims.
So what type of clients do you usually represent and work with? So you mentioned about this case and him having a case in the 60s against, was it a kids' home?
Yes, it was. Yes.
Children's home.
It was against a local authority, yeah.
Yeah, so what type of clients do you usually have?
My clients vary from very young children. I think my youngest client is about 7, right up to people who are in their 70s. For instance, I'm acting for a number of people who were abused in Lambeth homes. Some of my clients there were in homes in the late 40s, early 50s. So, I mean, we have people who are very old indeed. They are people who come from all walks of life. So they may be people who are professionals, basically, like me,
Yeah.
or they may be people who are working in all sorts of jobs. The point about child abuse is it doesn't discriminate. It doesn't
Yeah.
discriminate by what you do, or what kind of background you come from. It's endemic to society. So my clients come from a very wide variety of backgrounds.
And also as well, would you say that a lot of your clients, in terms of the time frame of their abuse, would you say that most of them are historical abuse survivors, or are they also victims and survivors who have gone through abuse quite recently as well? Would you say it's a mixture?
The vast majority are historical abuse cases. Most of my clients are above the age of 21, which is the limitation period for bringing a claim, although we'll talk about that later. So the vast majority of my clients, if you were to look at their age group, it's basically tends to be people in their late 20s, 30s, 40s, or 50s. That's the sort of age range that we tend to have. It's quite rare, not unknown, quite rare for us to act for people who are below the age of 21.
Would you say that it's because of the time it takes to disclose sexual abuse, or the time it takes for them to come forward?
The courts recognise that. It's recognised pretty much as a matter of law that if you've been abused as a child, you may take decades before you disclose anything. That is typical, I think. If we get somebody through our door, I think we had somebody through our door the other day who was 18 years old and wanted to talk about the abuse that she had sustained. That was exceptional. Most people, it's very difficult indeed for them to come forward until very late in the day.
Yeah, and I've seen some statistics that actually reflect that as well. So that does make sense that the law would take that into account. It wasn't always that way, though, was it, with the law that they did that?
No, it wasn't. I mean, as far as the criminal law was concerned, the criminal law has never had a statute of limitations, and that has been enormously important. So if you go to the United States, in certain states, if you try to bring a prosecution for child abuse, state law will say we'll have a very strict limitation period, and it's the same on the continent as well. There are very strict limitation periods. We don't have that in this country, and that's why we've had so many historic child abuse cases. As far as civil claims are concerned, there are more claims, certainly far more claims than there were when I started in the profession. When I started in the profession, effectively the time limit was 6 years from your 18th birthday. But that was done away with in 2008. There was a very big case called A versus Hoare, and that did away with that 6-year time limit and substituted it with a 3-year time limit running from your 18th birthday. And of course, the courts have the ability to extend that time limit in certain exceptional cases.
Okay, well, that's definitely good. And I think that's obviously something that should be encouraging to survivors as well, especially, those of us who were abused probably in the 70s, 80s. So in terms of child abuse compensation, can you share with us what types of compensation there are? So what are the different types of compensation?
Well, the first claim that should be considered by anybody who's been a victim of child abuse is a claim to the Criminal Injuries Compensation Authority. Now, that's a government body, and it's set up by statute, and it awards compensation if you've been a victim of a crime. Now, the time limit for making a claim to the CICA is 2 years from your 18th birthday, but in child abuse cases, you can make a claim as long as you do so within 2 years from talking to the police for the first time. Even then, you might be able to get over the time limit. My advice to anybody who wants to make a CICA claim is you do it now. You don't wait for a criminal prosecution. You don't wait for a trial to happen. You make the claim as soon as you possibly can. These time limits may assist you, but the best way to look at it is not to wait. So if you're within the time limit set out by the CICA, and they set them out within the scheme, then what you can do is you can put in an application. You don't need a solicitor to do it, but if you do have a serious claim, then my advice is that you do instruct a solicitor. The downside with that is you have to pay the solicitor out of your your compensation, and you could be paying anything up to 30%. It might be more, it might be less. But you put in the application online, you tell the CICA what your claim is about. They'll want to know about police involvement, and you will be awarded compensation according to a tariff. You can make a claim for loss of earnings. It's not easy to do, but it's certainly possible. So you make a claim for, you get a tariff award of the severity of what's happened to you, and then you can make a claim for loss of earnings. And I believe you can also make a claim for treatment. The claim itself shouldn't take too long. If you don't like their award, you can apply for a review, and after that you can go to an appeal. And even after that, there are other courses to appeal there as well. But the problem is that A, the compensation that you'll pay tends to be much less than in the next form of compensation that I'll be talking about. And B, you don't get costs, which means that you have to, if you instruct a solicitor, you've got to pay your solicitor out of that. But I always say to every client who has been a victim of abuse, but that's really your first port of call. That's what you should be looking at. And it may be that your solicitor can't take it on, but you can make the claim. It's not difficult to do.
You did mention that there is also another compensation route as well. Could you talk to us about that?
Yes, the other compensation claim is to make a civil claim. Now, the civil claim works like this. You make a claim against a person who abused you, but you can also make a claim against a person who may have employed the person who abused you or who let it happen. So typically, you may have a claim against a local authority if you're abused by a foster carer, or a residential social worker, might be a social worker, anybody who's employed by the local authority to look after children. You can say, well, the local authority is directly liable for what's happened. And that is the main route by which people get compensation. Now, that's a civil claim. You can also make a claim against the local authority if you can say, well, you were negligent in your care of me. So whilst I was in your care, you failed to look after me properly. Now, the limitation period for making a civil claim is 3 years from your 18th birthday. Now, there are exceptions to that. You may be able to get round it, but generally speaking, it's 3 years from your 18th birthday. Now, the court has the ability in certain circumstances to extend that time limit, but in my experience, they don't do that very often, and they only do that typically where you have been able to secure a conviction against your abuser. You've got the conviction there, and it's at that point, if it's say like a residential social worker who's been convicted of abuse, or a teacher who's been convicted of abuse, and he or she's gone through the courts, they've been convicted. In that situation, you may have a very good claim, because the court will take the view is, well, it doesn't matter that it happened 20 years ago. We know that it happened. There are no other issues to deal with other than the fact of whether that person is guilty. But we know they're guilty because the criminal court has done that for us. So those are the courts which typically, in my experience, will overcome limitation. But if you've got anything less than that, that's when it can get very difficult, I'm afraid. So that's the second form of compensation claim, and that's the one that I tend to run. But there's a third one as well, and that is a statutory complaint to the local authority. Now, the time limit there is 1 year, technically, from the time the abuse actually happens. Now, that is sometimes extended. So, I mean, I've had people who've been abused, say, at the age of 14, and they've come forward at 19, and they've been able to make a complaint. But I've also had people who are sort of in their early 20s where the local authority said, well, that's too long ago. It doesn't work like limitation in CICA or civil, where the time limit starts when you're 18. It starts from the time the abuse actually happens. If you're 4 years old, it starts then as well. And what that means is that it can be very difficult to get over that time limit. But if you can make a successful complaint, you can get some compensation. But the bad news is that it's a lot less generally than you get in a civil claim. And also, there are no solicitor's fees paid unless it's an exceptional case. And very few people go through that route. I mean, the complaints that I help with tend to be about other issues effectively. So it's not always open to people. But there's also a further claim, which is a claim in human rights. you don't see too many of these. And the reason for that is that damages, reported damages so far, tend to be a lot less than you get in a claim which is based on what we call negligence and assault. And also the time limit is very strict. It's 1 year, 1 year from the time the breach of human rights happens. Now you can get over that again, but again, it's a sort of another way of making a claim. But again, because the human rights limitation period is so strict, it can be very difficult. And also, courts may take the view that if you've got a human rights claim and you've got a negligence claim at the same time, then they'll just put them together and they'll award you effectively what they would have awarded for a negligence claim, but they won't give you human rights on top. I mean, they might have. It's quite a complex area of law. People are trying to develop human rights claims so that we can say, well, if you've got a human rights claim, it's worth the same as a negligence claim or an assault claim.
Yeah, I mean, just listening to you talk about the three different ways, you know, the CICA, the civil action, and obviously the statutory complaint, it doesn't seem to reflect what the law is doing in a sense, because obviously at the beginning we were talking about the law understanding that it takes a while for survivors to come forward and the law reflecting that, but it just seems like the compensation guidelines don't reflect that. Why do you think that is? Surely they should be in line with that as well also. For instance, I went through sexual abuse and I didn't really acknowledge what had happened to me until I had a breakdown at 22 years old. And from that point, I then had psychotherapy for a number of years. I was on medication and different things. By the time I felt at a point even to feel even ready to even look at compensation was many years later. And, you know, I think that the law should also reflect that also in the compensation guidelines. I mean, what are your thoughts on that?
You're absolutely right. The problem is that the law takes account of a number of different factors. So if you're making a civil claim, you're outside of limitation. The way that the Limitation Act works is it says, okay, so you're out of time. So we're now going to decide whether it's fair, whether it's just and fair for limitation to be overturned. So we're now 20 years on past limitation. Is it fair that we should overturn limitation? So they look at the interests of not only the person bringing the claim, but the person who's being sued as well. And what a court does is it doesn't just look at what you were thinking at the time. It doesn't look at that. That's not the only thing. Generally speaking, a court will say, if somebody comes to them and say, look, I haven't brought this claim because I found it very difficult, I had to have psychotherapy, I had to have treatment, a court will generally accept that. In my experience, a court will not say to somebody, you took too long. They will always accept that. The problem is what stops this are the other factors. And the other factors in the Limitation Act is that if you want to have a trial, if you want to have a trial of matters that occurred 20 years ago, a defendant will say, well, it's all very well for you to bring this claim, but first of all, we've got to know when it happened. Let's say we've got no conviction, so we don't know whether it happened or not. So we've now got to delve back 20 years ago. We've got to ask this person whether they did it. We've got to see who else was there. We've got to look at the notes. You know, no one's alive now, or they've all gone elsewhere. We can't find them. And that's how they defeat claims, so certainly civil claims, and to some extent CICA claims, and also on statutory complaint claims. They say it's all too long ago for us to be able to have a fair trial on what's happened. You know, if something has happened to you many years ago and there's no documentation to support it, or even if you do have documentation to support it, the defendant can generally just pitch up and say, well, these are issues where we can't have a fair trial because it's just too old. And the only way to get around that is to introduce what they have in New York. That's the state of New York, which is a limitation act that says that there is no limitation defence. And to some extent, they've done that in Scotland as well. So at present, we've got Ms. Giffray, who is suing Prince Andrew. Now, the reason why she's been able to bring this claim, and there's no argument about limitation or whether it's fair that she should have a claim, is because they introduced a limitation act saying it doesn't matter how long ago it is. Limitation arguments are relevant. And so that means you can make a claim. And there was an attempt to try to strike out that argument on the basis that it was unconstitutional. That was bound to fail. Court's going to say, well, of course it's constitutional. Legislature has brought it in. But
Yeah.
unless you bring in that kind of limitation act, like the one they've got in New York, that's what's difficult. Our present limitation act, which dates from, well, it's 1980, but it's a lot older than that. I think the first limitation act I saw was 1939. It's developed over the years. But the problem is that it's developed, but it still allows a defendant to say, well, this is all too long ago, and we can't find the records. And that is the reason why an awful lot of claims fail. In fact, most claims fail for that reason. I mean, there's other reasons for claim to fail, but limitation is a big one, I'm afraid. It's a big problem for vast majority of people.
I think it's a bit unfair, to be honest with you. Obviously, I know it doesn't boil down to fair and unfair, but I think that, if it's a problem with limitations, then that's something that should be looked at, because one of the things I think that always comes to mind with me, especially myself, of going through something like that, and then obviously, the past decade or so supporting other survivors and victims, is that there is an awful lot of things on the perpetrator's side. Going back even a few years ago, it was such a big deal in court because the right to be believed seemed like it didn't apply to survivors of sexual abuse, the right to be believed, because of the nature of sexual abuse, a lot of people don't have physical injuries from sexual abuse. The injuries are more psychological. So It's always this kind of thing of, well, you need to prove it. But the proof is there for a lot of people in their lives, for instance, in mental health issues, in psychological issues. But I do honestly think that is an area that should be definitely looked at. You also mentioned about in the civil child abuse compensation claims. What I wanted to ask you then is about if somebody wanted to take action against a family member that had abused them, how would that work then in the civil child compensation claims?
It would have the same issues. Whether you sue a local authority or you sue an individual, it's the same law that applies. The problem with suing a family member is question number one. It's not so much limitation, it's do they have any money? Because the cost of these actions is very high indeed. So let me just give you some figures. Anecdotally, the average child abuse claim settles at about £30,000. That's what I've heard from defendant solicitors, about £30,000. But the costs typically may be as much as £30,000. If you've got a very valuable claim, so let's say you've got a claim worth £150,000, which is perfectly possible, the costs of running that claim all the way to trial and enforcing that claim are probably going to be another £150,000. So that's £300,000. So if you've got a claim of that size, you need somebody who is worth at least £300,000, because it's not like a big local authority which has insurance, which has a lot of funds. You've got somebody who may be looking at losing their entire worldly wealth. And when I've seen people, individuals, that's literally what we do. We remove from them their entire worldly life. That means taking their house, selling it, taking everything that they've got. They may be left with a sort of minimal income or something like that. So a person in that situation may well think, well, I might as well just fight this. And that's what people who, even when they've been convicted by courts, they will fight it. So you've then got to enforce the action against them, and that costs a huge amount of money. So when you're looking at those sorts of numbers, unless you've got a defendant who is likely to be able to pay that, no solicitor is going to take it on, because there's nothing to be got. I mean, obviously you will get a judgment. In the meantime, the solicitor has to pay for this. Legal aid is available for these cases, but only for a tiny minority of cases. So effectively, it's the solicitor's money. Solicitor's money that goes into these cases. We have to finance our own clients' claims. And in order to do that, you need to have a realistic prospect of recovery, because if you lose too many of these claims, you simply go bust. Your firm will go bust, or you may lose your job. It's as simple as that. So claims against family members are very difficult indeed. The additional problem is limitation, because that defendant will say, well, this is a long time ago. There's no conviction against me. I'm not convicted of anything. And this is a long time ago. I'm expected to defend these matters. And again, we then have the arguments about limitation that come up. And that's why claims against individuals are quite rare. It's not that people don't do them. I mean, I have at least one claim.
Say, for instance, if that family member was convicted, does that make any difference?
Yes, it does. It makes a big difference. If they've been convicted recently, if they've been convicted 20 years ago, then there's a problem, because again, they can say, well, yes, I was convicted 20 years ago, but that is still a very long time ago. This claimant should have brought the claim after I was convicted. So the conviction only really works if it's relatively recent. You don't want to hang around too long after you have your conviction in place. So the bottom line is that limitation can be raised, but the real issue in suing an individual, the real issue that is foremost in our minds is, does this particular defendant have the means? Do they have the means to actually pay the judgment, which will include both damages and costs?
I get from what you're saying then is that with a civil action, even if they have a conviction, which is obviously a route that people can go down if they've got if they want to go down the route of civil action,
yeah,
it really does boil down to if they have the means to also pay for the damages and costs.
But you could make a CICA claim. You could make a CICA claim because you would say to the CICA, I've got a conviction here. And the CICA would say, well, right, well, if the conviction, and again, this is where the time limits lock in, because if say you're 40 years old and you've just had a conviction, you can say to the CICA, well, I went to the police in 2021, and that is less than 2 years, or we're less than 2 years on, therefore I have made my claim within the time limit set out. So a person who's in their 40s can make a successful claim with a conviction. They'll have a very good claim. CICA will pay out almost without question.
Yeah.
But the other thing to realize about CICA is that sometimes you don't actually need a conviction. You can still get paid, and many people do get paid without a conviction.
That brings me on to my next point that I was going to talk to you about, because I wanted to talk to you about the facts and myths in regards to child abuse claims.
Yes.
So you've just started saying there that you don't actually need a conviction for the CICA route if you were going to take a claim. So if you were going to do a claim. So can you talk to us about the facts and myths in regards to claims then?
Yes. I think that the first myth that we sometimes hear is that clients are told, don't make a compensation claim. Don't make any kind of compensation claim. Don't make a claim to CICA, and don't make a civil claim. Don't make any kind of money claim until the prosecution is over and we have a conviction. Now, that is wrong. And the reason why it's wrong is because the time limit is ticking against you. So if you're making a CICA claim, the time limit is 2 years from your 18th birthday if you're a victim of child abuse, or 2 years from the first time you went to the police. But it can take more than 2 years. And with the COVID epidemic, prosecutions can take 3-4 years before they actually come to fruition. So that's why you must make the claim as soon as you possibly can. If you're making a civil claim, there are things that can be done to stop the limitation clock running against you.
Yeah.
With CICA, as long as you file the claim, you make the claim, the CICA may wait until the prosecution is over and until there's a conviction. But even if you don't get a conviction, because there'll be a lot of evidence there, if the police feel that this was something that happened, because it's on the balance of probabilities, it's not according to the criminal standard, you will be compensated. So that's really myth number one, is that you shouldn't make a compensation claim until after the prosecution, because it may prejudice the criminal prosecution. But in my experience, it doesn't, because juries are well aware that people make compensation claims. They're well aware of the whole process. And they don't tend to look at that. What they look for is inconsistencies in what the claimant is saying, or inconsistencies with other evidence. That's really what they look at. That's probably the main one that we come across that probably prevents people from making successful claims.
Yeah.
It's once you realise that you have a claim, then it's a time to talk to a solicitor. And there's no lack of solicitors in this field who will give you decent advice as to what you should and shouldn't do, and they will be able to spot in a very, straight in a very small amount of time whether you should be making that claim or not, or the type of claim that you should be making.
In just what you said there, I just think as well that there is not a lot of information out there about child abuse compensation claims as well.
Best way to deal with it is go to an experienced solicitor. So you need to go to an experienced solicitor who's actually done these sorts of claims before, and who has done both CICA and civil claims, and who understands the interplay between them and how they're going to work. You can go to as many solicitors as you like. Generally, if you haven't got a claim, you'll get the same answer from all of those solicitors. But the more experienced a solicitor, the better, because we do take on civil claims, quite a few actually, where there is no criminal prosecution whatsoever. Yeah. So there's no criminal prosecution, no input from the criminal process, but we make the claims and we make them successfully. So one classic example of that is the Lambeth Children's Home scheme, which by its nature is actually confusing because it talks about children's homes, but you can also make a claim for if you're abused in foster care in certain circumstances. Now that scheme sadly has now closed. It closed on the 1st of January this year, but that scheme did not require you to have a criminal prosecution. And I mean, most people who made the claim were never part of any criminal prosecution. And also importantly, there was no limitation. So you could make a claim from the 1930s if you wanted to, and nobody would say anything about the time elapsed. So those sorts of claims, and they resulted in quite high settlements as well. So if you can put yourself within the part of the scheme, they are not subject to these rules of limitation. So I deal with at least 2 other schemes involving child abuse. And in those claims, we don't need to worry about police involvement, don't need to worry about a criminal prosecution, don't need to worry about limitation. The claims are just paid according to the terms of the scheme. So that's why it's important to have the right solicitor, because they'll be able to say, well, you may not have a civil claim, but you could be part of this scheme effectively. So that's why it's important to go to the right person.
Okay, but with the schemes, is that more like, for instance, like a collective action, for instance, against a local authority? Then how I'm interpreting it is that a group of you, or maybe some of you, have been abused within a public kind of institution, and that has formed a scheme.
Yes, that's right. So in Lambeth, there were so many people who had been abused in Lambeth Children's Home and in foster care. There were so many people that they all got together under the umbrella of an organisation called the Shirley Oak Survivors Association, and SOSA pressed the local authority. They pressed the local authority, said, you're going to have to pay up for what you've done over the years. And Lambeth did. Lambeth set aside 120 million, and they paid, I think, close to or over 120 million to all of these people who are in children's homes. So if you could fit yourself within the terms of that scheme, you could actually get paid. In relation to other schemes, they only apply to certain types of institutions. So I'm advising a survivors organisation in relation to a religious organisation that operated in the Midlands from about the late 60s right up to the 2000s, and well, right up to now it's still going, and they're setting up a scheme at present to compensate people who as children were members of this church basically, and who suffered abuse. And then there's another scheme in which I'm involved, involving people who are at a private school, who between 1975 right up to the 1990s were mainly physically and emotionally abused, and a scheme has been set up to compensate these people. So issues of limitation, issues of prosecution are not relevant to these schemes. You are paid according to the terms of the scheme. Islington, London Borough of Islington, has set up a scheme which I think pays, I can't remember the exact amount, I think it might be £8,000 or £9,000, but it pays £8,000 or £9,000 to each person who was in their care or in a children's home. That's not such a generous scheme, I have to say, and there's no solicitor's costs at all. So if you can fit yourself in the terms of one of these schemes, then you can get some compensation. But there aren't that many of them.
Just from listening to you, the schemes seem to fit around a certain people that have gone through certain experiences, for instance, within a local authority. For those of you watching, a local authority is equivalent to a district council or a county council. That's what local authority over here in the UK are. Yeah. With the majority of survivors that I've worked with and supported over the last decade have been abused by someone they know, love, or trust. Obviously, you said that the compensation scheme doesn't apply to them, but if they've been dealing with the aftermath of the abuse that was done to them, and it has, like, for instance, medical records, or like they've attended therapy and different things like that, are those type of things taken into account?
Yeah, oh yes, they are. I mean, it depends very much on what type of claim you've got. Let's say that there's no limitation problem. Let's say that there's no limitation issue. Then your medical records and your therapy records will be very important. And the defendant will want to see those records. They'll want to see them. Because if you're saying, well, you know, I've suffered all this trauma and I've not been able to work, and I've not been able to do this, that, and the other, then you'll need to put together some pretty heavyweight evidence to back that up. And that starts off with your records over the years. So, you know, it could be tax records, it could be medical records, psychiatric records. I mean, in Lambeth, it was quite common for us to have records from 5, 6 different sources. So yes, all of these records are very, very important indeed in proving the value of your claim. When it comes to limitation, medical records are obviously important, but they won't necessarily get you over the line with limitation.
But how about in the case of the CICA claims? Because obviously you said there's a limitation there, like 2 years from when you first report it.
Yeah. So if you're within that, that's fine. But if you're outside,
would it be made an exception? Would that be made an exception to, maybe, because obviously therapy is very expensive.
Yes.
And a lot of the time, a lot of survivors who have been through childhood sexual abuse have to go and find their own specialised therapy, because on the NHS over here in the UK, and I've been through this process many times myself, they won't specifically assign you to a therapist who deals specifically with childhood sexual abuse. And for anybody that's gone through it, they need somebody who's able to handle that issue delicately. And usually, like when I was attending specialised therapy for childhood sexual abuse, that can cost up to £50 a time. Is there an exception for therapy costs? I know about the limitations with the CICA, but the fact that, you know, you've had to pay this money to, you know, do therapy and all these other things, would they see that as an exception?
No, it's not an exception at all. I mean, you can make a claim for therapy. It's perfectly possible to make a claim. But the thing to understand about limitation, this is really important, is that what the law does for child abuse survivors is it puts forward a number of obstacles in front of you. And you've got to understand that they are obstacles that you have to cross.
Oh, okay.
If you can't get over one, then effectively you could lose your entire claim. If you can't get over the next one, you may only get half your claim or only a fraction of your claim. But the very, very first obstacle in every single claim is going to be limitation, because people, as we were saying right at the beginning of the interview, you know, these are historical claims. Yeah. If you don't get over limitation, that's it. You can't make a claim. So the fact that you've got therapy records isn't really going to make any difference. What the court is looking at is it's looking at the whole picture. So the civil claim picture is it fair for us to have a trial and look at all these issues, whether it happened, how much it's worth? Is it fair for us to have a trial of these issues when we're 20, 40 years on? If the answer is no, that is the end of the claim. You cannot make a claim. Now, if the court waives that obstacle, so let's say you get over limitation, then the therapy records and medical records become more important, because the other side will be looking at those records and they'll be looking to see whether they corroborate the kind of trauma that you now say you've got, and whether that trauma is caused by the abuse or whether the trauma is caused by something else in your past. So a common problem with child abuse claims, when you're looking for high numbers, you're looking for, you know, big claims going on over 100,000 up to 1 million, whatever, is that there'll be a concerted attempt by the other side, this is in a civil claim, to say, well, actually you had a rather difficult childhood. Apart from the abuse, actually you had this medical condition, which was nothing to do with us. And that effectively would have caused those problems. Now we call that issue causation. And that is a major problem in child abuse cases. And it tends to be the second obstacle. So first obstacle is limitation, second obstacle is causation. With CICA claims, if you're past limitation, you don't have a limitation problem with a CICA claim. In my experience, causation isn't something that you have to worry so much about. And there's a reason for that. And the reason is that the CICA are not like a defendant saying, well, we want to see this, and we want to see that, and why are you saying this? The CICA doesn't behave in that manner. Effectively, the only evidence that it gets presented is evidence from you. It doesn't, it may sort of start asking a few questions, but by and large, you can actually get quite high amounts, and people have done it from the CICA simply because they got the right evidence together. Now, it's at that point that if you get your medical records, if you get your therapy records, if you get a report from a psychiatrist, which is very expensive, but it can be done, if you get all those things together and you present a good enough case, you can get quite a high award. Now, you can do that in a civil claim, but the problem in a civil claim is that the defendant will have their own psychiatrist. The defendant will have their own records. The defendant will ask all sorts of questions. So that means that your claim, you say it's worth $1 million, the other side come back and say, no, it's only worth 20,000 or 30,000. That's the problem that people have.
Oh, it seems to be quite a complex ground, and it's definitely something I think if you're a survivor and you're looking into it, you're definitely going to need some type of advice and guidance in being able to do it.
You can't do it yourself. I mean, even if you're doing a CICA claim, and this is why it's always worth going to a solicitor, because you can ring up any solicitor. You're not paying anything. I mean, nobody who rings me is charged any money. In fact, they're not charged any money even if they do make a claim, because the whole idea behind making one of these claims is that people don't have to pay. The cost is borne by solicitors. Some of that cost may be borne by insurance policies or whatever it may be. But if I said to people, well, you're going to have to give me £10,000 on account, no one would make claims. Why we have no win, no fee agreements, and that enables people to get some kind of justice without having to pay huge sums up front, which would just make the whole thing ridiculous. And I mean, the other issue is, of course, if you do sign an agreement with a solicitor, you need to be clear what you are paying, because of course, we are entitled to charge people out of their damages in certain circumstances. That should be set out very clearly right at the beginning. Say, look, this is what most solicitors do, is they say, we'll never charge you more than 25% or 15% or 10%. That's the bottom line. Never take more than that amount of money away from your damages, basically. So it's important to get that right.
What is the best case or grounds for a survivor then to seek compensation? Considering all that we've spoke about and all the different kind of challenges.
I think the sort of case that we would take on is a survivor who comes to us and they say, I have just walked out of a Crown Court, might be a magistrate's court. I've secured a conviction against my abuser, and my abuser is employed by an institution, or my abuser is demonstrably extremely wealthy, which is very rare indeed. So generally it is an abuser who is teacher, residential social worker, somebody foster carer as well. Those are the best sort of case. Those are the cases that tend to succeed. Those are the cases where we will be saying to clients, we will take on your claim, and any deduction that we're going to be making is going to be low because the risk of the case is low.
If somebody's gone through sexual abuse at the hands of somebody and hasn't seen them in years, or doesn't know the ins and outs of their life, they don't know how much money they've got. A lot of people,
it's quite easy. You can work it out quite easily, though. It can be done.
How would you do that?
Well, quite simply. I mean, a wealthy person is going to live in a house. They'll live in a house. You do land registry search. It takes 2 minutes. A land registry search will tell you whether a person owns a house. It will tell you, you can find out how much a house is worth, very easy to do. And you can find out, you can't find out how much if they've got a mortgage, how much the mortgage is, but you can generally guess.
But even people who have got money, even people that have got money might not necessarily own a house. They could just be renting. I know people that that are renting, but they've got money. They don't have a
well,
mortgage.
yes, then it is more difficult. But in my experience, from the people I've sued, are wealthy people tend to own their houses. Basically, they don't
Okay.
tend to rent. Yes, of course, if they are renting, it is more difficult. But then you've got to ask yourself, if you've got hundreds of thousands of pounds, why would you keep it elsewhere? I mean, one does hear of people who sort of squirrel money away in the Virgin Islands or something like that. But in my experience of every claim I've ever had, it has never been difficult to ascertain how much a person is worth.
Okay.
It can be done. What you tend to get is people saying, well, so and so lives in rented accommodation, but I know he's very wealthy indeed. She's very wealthy indeed. But when you actually drill down into that and you actually find out, because they may own a business, it turns out that the business actually isn't actually worth anything, or is worth very little. And in fact, they're not earning huge amounts at all. So it can be done. It's not as impossible. I think the most important thing is that again, this is one of the sort of a lot of survivors sort of think, well, I can't make this claim because so and so is renting and therefore they haven't got any money, or so and so will squirrel their money away, or they will instantly a claim is made, they will divert those monies overseas or something like that. And yes, all these things are possible, but there are ways to stop it. There's ways to stop that, to stop them squirreling money away. It can be done, and I've done it. And if you go to a solicitor with experience in suing individuals, they'll tell you how it's done, and they'll judge whether in fact it is worthwhile or not. So okay. I think sometimes survivors will come up with reasons as to why they shouldn't make a claim, because there's this problem or that problem. But unless you understand the complexities of the law and the way the legal system works, and the way that people tend to hold their money, you could be under a sort of complete misapprehension. And I have seen people say, well, I'm not going to make a claim. I'm not going to make a claim. And the reason why I'm not going to make a claim is because I think they've got no money at all, basically. And it's not going to work. But if they were to talk to a solicitor might say, well, maybe they haven't got any money, but you've still got a CICA claim. Had you thought of that? So a lot of survivors that I have may actually have claims, but they've told themselves that there is no claim because somebody who doesn't really know about how they work has said, well, you can't do that because I've heard that it'll muck up your criminal trial, or I've heard that it's impossible to sue an individual.
I mean, just from listening to you, it does seem, in terms of people that have been abused by institutions, that things might go more favourably for them.
Absolutely. I mean, it's rare for me to take on a claim against an individual, and we only do so in certain circumstances.
And those circumstances being included knowing the person's their assets, net worth, to see if it's worth taking on.
But again, I mean, it can be done in literally a couple of hours. I mean, you can hire an inquiry agent for a couple of hundred pounds to do a check on somebody's assets. But people don't sort of abusers do not tend to behave like international criminals, basically, who manufacture false identities. It's not what they do. What abusers are, as you say, it's people who you love or you trust, and that's how they do it. If you're sort of flitting around the globe all the time and no one knows where you are, it's going to be more difficult for you to abuse members of your own family. What you need is a position of power and trust within the community in order to get away with the abuse. That's what people do. Right. So if you own your own house, you are seen as somebody who is solid, reliable. Therefore, and that means because it's your house, it means you can invite children in. So I dealt with a case against an individual who used his house to invite children from the street into the house so he could abuse them. And he did this over a period of years and was eventually convicted. But he owned that house. And we were able to take that house away from him. But I've seen this at least 2 times, 3 times. They use their economic position to entice children in. They've got a place where they can abuse, and then they use what economic power they've got, because frequently they have more earnings, say, than the children's parents, and so on and so forth. They use that as a means of being able to abuse them, and that's key to being able to abuse. The way that abusers work is nearly always, it's extremely subtle. They will manipulate the system, but without a position of trust. Jimmy Savile could not have got away with what he did unless he was in a position. People say he was abusing in plain sight. He was, but he was able to do that because he was the man who was going around hospitals effectively ministering to sick children. Who would question a man like that? That's how he was able to do it. You know, he was also a DJ. He was very respected in the charitable sector. People may have been spreading rumors, but he was a very wealthy man as well. And people did sue his estate after he died. There was an action against it.
Which I definitely am aware of, but I'm just thinking more of the everyday survivor, the ones that are not abused, are under any scheme, or abused by any kids' homes and things like that. I think it's been eye-opening to have this conversation, because the majority of survivors are not abused by, in a church setting or in private schools, boarding schools and stuff like that. I mean, what would be the next steps, would you say to them, to then, if they're interested in finding out more information?
I think the thing is to ring a solicitor.
Ring a solicitor.
And make sure that it is. I mean, generally what happens is that a claim is assessed, and because there are so many claims that come our way, so many people approach us, very often that claim may be assessed by a paralegal, but it doesn't mean to say that it doesn't mean to say that people are getting shortchanged. It just means that the paralegal may well be discussing it with somebody who's senior. The point is that they need to talk to somebody who actually specialises in these claims, and who can give them robust advice right from the start, because there's nothing worse than saying to a person, there might be a claim, we could do this, we could do that. I think you have to be truthful. You have to be truthful with all survivors of abuse, and you have to give them the bad news early on. And also, I mean, there's no harm in trying different solicitors, but as you say, it is only a tiny minority of people who actually have compensation claims. I mean, the percentage that I calculate in my own experience is it's less than 2% of people who approach us actually have claims or have viable claims, I'm afraid. People, as you say, who are abused by typically family members, basically, those people, by and large, don't have any kind of recourse. And if there's no conviction, it's going to be very difficult to make any compensation claim at all. But there may be something that they're missing. They may not have realised, for instance, that at the time that they were being abused, they're actually in care. So if they were in care and they were being abused,
but then again, even to be in care, I was in care. I don't know any other survivor apart from probably 2 or 3 that were in care. A lot of survivors that come through this organisation, and I have over 10 years experience supporting victims and survivors, were abused by somebody within their family circle. Some were abused by maybe somebody in the church, like a school Sunday school teacher, somebody like that, an imam in the community. But a lot of cases, it's siblings, it's parents, it's uncles, it's all this type of stuff. I think on just having this conversation with you, I think obviously it's been very useful. And I think that what would have been great actually is if, I don't know if it's the government's responsibility or whose responsibility it is, to make all this information available to survivors. I think there's a lot of other information that should be made available to survivors, not just child abuse compensation claims information, but I think there should just be something where there is like a central hub, a central type of website or something where all this information is on there. I think that as well with the limitations, it's quite disappointing, to be honest with you.
It's extremely disappointing. Yes, I agree.
And I am speaking as somebody who was a victim of sexual abuse. to hear this. It does always feel like the survivor has to do so much to prove that they were abused all the time, whether it's criminally,
yeah.
whether it's to go to court, whether it's to go to the police, all these different challenges all the time.
Okay, but we were talking earlier, weren't we, about myths and legends? And I've just thought of another myth and legend, and that is that people say, "Well, I'm not going to go to the police at all," and we get a lot of that. People say, "I'm not going to go to the police," and the reason why I'm not going to go to the police is because there'll never be a criminal prosecution.
Yeah, but if you think about it, for a survivor to say that to you, they're coming from a place of not being believed in the first place.
Yes.
So that mindset is automatically there.
What
uses it because they felt powerless in the first place.
That's certainly true. Yes, yeah. That's certainly true. However, it's not the case that if you don't go to the police, if you go to the police, then nothing will be done. It certainly was the case years back, but it's less so now. What people sometimes don't realize is that, first of all, if you go to the police with an allegation, they are bound to investigate, they're bound to look at it. Secondly, they are also required by law to give you a certain amount of support and explain what they're going to do. They are in a lot of trouble if they just say, "Go away, we've got better things to do," which is what they used to do. The other thing is that the police have information that we don't. So they have information on a large section of the population. And sometimes people will think, "Well, I'm the only person who's ever abused."
Yeah.
But abusers are prolific, as we know, and
yes,
they will have several victims. But it's quite common for those victims not to have the first idea that there are other victims out there. In fact, that's one reason why once a prosecution starts, once it actually starts, that is, very often it has a high chance of success. The reason is that if you line up 3 people in front of a jury and it becomes plain that none of them know each other, but they're all saying the same thing, that's extremely powerful evidence. Now, sometimes people will say to me, "Well, I'm not going to go to the police because it may hurt a member of my family." And I mean, that's a decision that they've got to take. But what we say to people is forget about the compensation. The issue is one of safeguarding. Once you make an allegation against somebody, and I've seen this happen in practice, once you make an allegation, it doesn't matter if they're not prosecuted. If you're making an allegation to an institution, such as a local authority, but it might be a school, they are bound to investigate it, and they are bound to ensure that that person isn't still abusing. Because an abuser may start off in their 20s, but they'll go on until their 70s. And I mean, we have examples of people who've been, I have an example of an abuser who was first convicted of an indecent assault in 1939. And I think his last assault happened in around about 1985, basically.
Well, this is one of the things I always say on this channel. Paedophiles do not change their spots.
Exactly.
And just to back up what you said there, I've had survivors who I've supported who have years later gone to the police and it's gone to trial. And during the course of the investigation, the detectives found out this uncle, this family member didn't just abuse this person, they've abused a neighbor's child. They've abused, so they are very prolific in how they do things. Paedophiles don't just stop abusing. And I just think that it's very difficult for somebody to go to the police. It's immensely painful. It's traumatizing. And when you're thinking about going to the police, you're thinking about all different types of things. You're thinking obviously about your family members. You're thinking about the shame and guilt that you feel, all the kind of stress and things that you've got going on. So it's not black and white.
It never is. But the point that I'm making, which I think you've made as well, is that sometimes just taking that step can have far-reaching consequences.
Yeah.
Very far-reaching consequences. I mean, all of the big criminal prosecutions have started off almost if by chance, by somebody talking to a social worker and saying, "Well, when I was in that home, this is what happened." 4 or 5 years later, you've got somebody who's in prison for 20 years and a whole host of victims basically who have been located, and that won't be the totality of all the victims. But nowadays, the sort of abiding lesson which has been learned not just by the police and social services, but also by institutions which have charitable status or who have to look after children, is that if you don't take an allegation seriously, in other words, if you say, okay, well, let's pay that person off and they make them sign a non-disclosure agreement. I mean, I know solicitors who will actively advise their institutional clients not to do that under any circumstances, because it's a breach of safeguarding. That is a safeguarding breach. If you don't take that seriously, you could be in serious trouble with the authorities. And that's, I've been doing this type of work since 1994, and that's something that I have perceived, certainly in the last 10 years, that all of a sudden it's not just presenting a compensation claim, there is a safeguarding aspect to it as well, which is actually very serious indeed. And indeed may be so serious that it actually holds up the compensation claim. That doesn't mean to say that you shouldn't make a compensation claim. It may be that you've made the compensation claim, but it just needs to be put on ice, which can be done legally. But the institution then has a duty to investigate and see, well, what are we doing? What are we doing about that person who was a teacher? What are we doing about that person who was a social worker?
Yeah, I definitely do think it should be required that they report, especially people in these positions.
Well, we don't have mandatory reporting, unfortunately. Which
this is what I was just about to get onto. What was your thoughts on mandatory reporting?
We should have mandatory reporting as they do in the United States. I mean, it is ridiculous that we don't. There is an organisation out there, I think they're called Mandatory Reporting, but they've been lobbying very hard for mandatory reporting. And to my mind, I am baffled as to why it has not been introduced. And people are prosecuted in other jurisdictions for not reporting. But we've had so many cases. We've had cases in the Catholic Church and in the Anglican Church. We've had it with social services. Lambeth is a classic example of not reporting, when mandatory reporting there was no reporting of abuse. And all it means is that effectively you are allowing somebody to continue to do damage to children. And if you are a social worker and you are charged with the safety of children, why is it that you can't be prosecuted for abandoning that? And remember, the vast majority of safeguarding investigations, it may be that they go nowhere, but this is another myth. People think, well, unless we get a prosecution, unless we get a conviction, then we can't do anything. And that is complete nonsense, because safeguarding is not about prosecuting people. Safeguarding is about safeguarding people.
Yeah.
So if you start asking someone who's an abuser, right, we're going to have an interview, basically. We've reported this matter to the police. It may be that the upshot of all of this is that the police can't take any further action. It may well be that the upshot of the safeguarding interview with the abuser means that there is no action to be taken. But the reality is that the abuser, who we often forget about in this process because they have thoughts and feelings as well, they may actually either abandon their activity, they may move out somewhere else. But the point is, it goes on a record. I mean, the disclosure and barring service, you don't need a conviction to go onto that register. You go onto that register if it's felt you've been inappropriate. So I mean, we have a case where, a teacher left the school. We don't think that they were ever put on the DBS, but they left the school. Now that effectively you remove that danger. That danger might pop up elsewhere, but there are a number of different things that happens. But doing nothing because you say, well, we can't really do anything about it, is fatal.
And I do also think as well, mandatory reporting should also be extended to parents, caregivers, anybody that is aware of abuse, not just in institutions or teachers or staff. It needs to be also people within families as well, because a large majority of child sexual abuse is within the child's family social circle.
And it is known about,
And it's known about, and it's condoned.
One of the things I think there's a case for that.
One of the things that I talk about a lot, because I am from the Black community, is that there is a lot of incest within the Black community. a lot of stuff that has gone on within families. Within my own family, the abuse was widely known, and my dad had abused before as well. So I think that mandatory reporting is definitely important. But I think this conversation has been definitely interesting, definitely valuable. I mean, there's a lot of things that I didn't know, and I'm sure those that are listening probably, you know, didn't know a lot of the things that you shared with us today. So is there anything else that you want to share with survivors who are watching this video, if they do feel that they have some type of grounds or not sure to contact a solicitor?
I don't think so. I think the only other thing that I would add is that, you know, do not be frightened of solicitors. You know, first of all, they're not going to charge you for ringing up. But the other thing is that because we do these cases, we do understand that people are going to find it very difficult to talk to us. And that means that we approach people in a sensitive way. So if I'm taking a statement from a person, if I need to take a statement, you know, we won't just simply take the statement. There will be a discussion, first of all, about what the statement entails. And very often I say to my clients, I'm not actually interested in the abuse because you may have told somebody else. And if you've told somebody else already, then we can get that record. We can use that record. We're more interested in establishing what your chances are on limitation, what your chances are on establishing damages. We're asking questions actually that are not in fact connected to the abuse whatsoever. You know, it's a lot of humdrum things that effectively, and yes, it takes a long time. It may take several hours to do, but you know, giving an account, we will always treat you sensitively. You know, you're not expected to sit there for 7 hours or 4 hours. You can always take a break. And in my experience, people can give statements basically. So there's always a structure to the way in which this is done. We always explain things and how they're done. And that approach is generally successful. So even if you don't have a claim, you know, you'll be talking to somebody who's going to treat you with the greatest of respect, because effectively that's how they make their living. Basically, you make your living out of people who are making these claims. So they'll treat you with the greatest respect. They'll treat you with sensitivity as well, and they will give you the truth. They won't lie to you. Basically, it's not in their interest to lie to you or to sort of give you false hopes. So don't be afraid of the legal profession, because it's really, if you can find a specialist, you know, it is somebody. And also they won't just, I mean, we certainly don't advise people solely on compensation. We will advise people on safeguarding implications. So if they're worried about what's going to happen to their family, yeah, how the family might react, you know, what it'll mean, we can actually give them advice from a vast store of experience as to what tends to happen in these cases. You know, what happens. I mean, some of my clients are terrified that their families are going to commit some kind of reprisal against them. And in my experience, that just doesn't happen effectively. Once you've gone to the police, it just doesn't happen. And in cases where it's meant to have happened, it's never anything that's actually that serious at all. So it's things like that. You know, you don't know. You don't know what's going to happen. It's our job as solicitors to try to lighten up the path. You know, put lights along the path. These are the paths you've got. Here's a light. This is where it's going, basically. Yeah. This is where we think it's going to go. This is a kind of protection that the police or social services can give you. This is the sort of thing that abusers tend to do. And sometimes we can actually predict their behavior. Because they do tend to behave in a peculiar way around things. But it may not be the way in which the victim anticipates that they are going to behave. So it's not just compensation, it's other things that we can help them with. We can help them with the criminal process too. We can say this is the way it's likely to go, it's how long it's going to take. I'm not sure there's going to be a criminal prosecution, but it doesn't matter, basically. Yeah. So many clients would say, we're not concerned about the criminal process. It doesn't matter. You've got a claim. Okay. So the first step and the best step for them is to get in contact with a solicitor. I just had one other quick question that I just remembered as well. Just in terms of the claims, whether it's the civil compensation claim, the statutory or the CICA, how long is the time frame for the process to go through from making a claim? A very long time. Yeah, very long time. It's literally, it's years. I mean, it's years. I mean, in Lambeth, in a scheme claim, I think it was 2 years at least 2 years.
Okay.
I think
And
the longest client is about 4 years. I've still got
okay.
clients who I took on 4 years ago, or 3 years ago, basically. 3 or
And
4
how
years
about
ago.
in a CICA claim? How long does that
CICA is
process take?
quicker. CICA is quicker. So if you go in for a CICA claim at the end of the prosecution, you've got a criminal conviction, or at the end of the criminal process, generally you probably get an award within a year, I'd say. So
And without a
CICA is always
conviction?
quicker. Probably the same, because the police will provide the information. So generally speaking, you know, whether you've got a conviction or not, I would say it's up to about a year. I mean, obviously, if you go through the appeal process, then it will take a great deal longer, and you might be there for years. But you know, to get a first award in place, it can be done within a year. The statutory process of making a complaint, I'm afraid, does take a very long time.
Okay.
I mean, there are time limits for them to deal with them, but they never. In my experience, it's quite rare for a local authority to be able to deal with that within the regulations. I mean, they can ask for more time, and I mean, I've seen complaints that have been going on for 2 or 3 years, so it can take a very long time. Finally, with civil claims, we will generally say to people for any civil claim that the time limit is at least 2 years, basically. So it does take a very long time. Yeah.
So with all those options, if they're eligible to proceed with that, it is quite a lengthy process.
It is a very lengthy process. Yeah. And I mean, during, I mean, civil claims, it doesn't matter what you're doing. I mean, the whole compensation process is not designed to be it's not a therapeutic process.
Just listening to what you've just said there, in order to go through the child abuse compensation process, whatever they decide, they need to have some type of support in place to be able to do it.
I think it's very helpful. Yeah, I mean, not all clients do this, but I mean, some clients of mine, the ones who are suing the religious organisation has actually put in a counselling service, and it is a counselling service which is specialised in dealing with survivors of religious cults. Okay. Which is it's a sort of different type of abuse. I mean, obviously there's physical and sexual abuse going on, but you've also got indoctrination, brainwashing, that sort of thing. Yeah. And it produces possibly a different psychiatric result. Yeah. But Lambeth put in a counselling service. This other organisation has put in a specialised counselling service, which I think is very effective, and people speak highly of it. Solicitors can't do that. We're not counsellors. If you can get hold of some kind of counselling or some kind of therapy, that's really helpful. Bear in mind that, you know, if you go to a counsellor and you go to a therapist and you make a claim, if you're making a civil claim, the defendant is entitled to see those records, and therapists are understandably nervous of releasing records where they've said to people this is entirely confidential. But my experience is that if you accept that your records only go to a very discrete number of people, it doesn't go to you, it's very rare indeed it would ever go to your abuser, and that you can stop that from happening, basically. And it goes to people who are professionally involved in assessing a claim. That's what they do. You know, they're not banding it about all over the place. And if they do, they're going to be sued for huge amounts of damages. So they're not going to do that. But as long as you understand that process, but it's a mistake to think, well, because I'm going to a therapist, then that means I can't make a claim, or I shouldn't go to a therapist because I am making a claim, and that's just nonsense. I would always encourage people, if they feel that they need support, then it's a good idea. Therapy is not a subject which I pretend to understand very well. We do make claims to therapy, but we do find that the majority of our clients don't actually undertake any therapy at all. So even though we claim for therapy, that they may not actually use the money to go into therapy, and that's their actual choice. But the only thing is that I think you've got to find the right type of therapy that works for you. In other words, it's actually going to make you better. It's going to enable you to move forward, because the whole idea behind treatment and therapy is it makes you better. It makes you able to deal with situations which you couldn't deal with before. So, you know, we have had people who have been in counselling for a very, very long time. It doesn't seem to have made any appreciable difference to them.
I think as a survivor, as somebody that's gone through it, I know what's going to be helpful to me out of that therapy. And another reason why they might not have been helpful to them, maybe they're not in therapy with somebody who is specifically trained to deal with childhood sexual abuse.
Well, that's what I meant.
A lot.
Yeah, that's what I meant. And we do, I mean, where we have used therapy during the course of a case, it tends to be with young children. So you've got young children who've been abused, and we can set up therapy for them. I mean, we have a dedicated practice, well, not a dedicated practice, but we have a practice of therapists we use for both adults and children. And they, we know them well because we've used them in a number of cases, and they tend to be quite practical in the therapy that they adopt. So a lot of it will be about what is it that you can't do, and how can we help you do that thing that you can't do because of the problems you're having. And it isn't always successful, but we have seen it to be very successful. So with children, for instance, who are, say, moving from schools, they will actually talk with the school and help the school assimilate that child with that child's problems into the school, and that can make a huge difference. So I'm always interested in the idea of treatment and therapy because it can make a difference. But at the same time, we've also had other cases where I just don't think it has helped at all. And I think we have to be, particularly if you're running a compensation claim, it's an issue that's looked at in great detail by the other side. Also, in a great many cases, when we instruct psychiatrists, they will say, well, if so-and-so has this type of therapy, cognitive behavioral therapy, it might be EMDR, they will improve. They will improve to the stage where they will be able to do this, that, and the other. And I often wonder, because often the cases are settled before that actually takes place, I often wonder whether in fact they do improve, if the therapy does actually work or not. It is a difficult area, I have to say.
What kind of evidence would you be looking at somebody who has had therapy, whether it's worked or not?
What we would generally do is you would send that person to a therapist. You would expect the therapist to keep records as well. Now, this is another issue, is that very often we find that therapists don't keep any records at all. So I think we applied for some records from somebody recently, and all the records were simply a record of every time that she'd been to see the therapist. There were discussions, but the discussions were never recorded. So there were no records, essentially, other than the fact that she had gone to therapy. From a legal point of view, that creates difficulties because we don't know what the therapy is doing, and we can't see how that person was during that time. So from a psychiatrist's point of view, and typically we have to use psychiatrists for these cases, we don't use psychologists, not generally. From a psychiatrist's point of view, they will be interested in those records to see how the person has progressed during that time. But if there are no records, then obviously there's nothing for us to use. That's the thing.
Yeah, and I can understand that, but I think even if there's not records, or whether there's records or not, I think it's the individual who will know how that therapist has benefited their life.
Yeah, absolutely. Yes, they can talk. They can talk about that. There's no doubt about it. Yeah.
And the whole point of therapy is to be able to feel free to talk about the deepest things that have hurt you and troubled you. It's something that it should be private. So that's again, something that survivors will have to consider if they have grounds to be able to go forward. But it's been very interesting talking to you about this. And as I said, I want to thank you for sparing your time today to share with us about child abuse compensation. So if anybody as a solicitor wanted to contact you, how would they do that?
They would simply contact me at my firm, and we have a system whereby new clients basically are interviewed, and it'll be a conversation on the phone. So we have a number of criteria that we're looking for. We'll explain what those criteria are. So anybody who rings us, effectively, we will give them probably a yes or no on the spot, but it will be explained to them in detail why we're not taking on their claim or why we are taking on their claim. So they will have a reason. So it may be something that's entirely oral. It's a conversation, but that's generally the way it's done. that it's a simple conversation, but it's a legal conversation. So we're not going to say to people, we're not going to give you any advice. We are giving out legal advice, and the legal advice is perfectly free.
Yeah.
And it will be, we will give them a reasoned answer as to why we think they've got a claim. So it won't be, sometimes we will say to a client, well, this is too complex for us to take on, or it may be a claim that needs a lot of work right at the beginning. But generally speaking, when we turn down a claim, we will give the client precise reasons as to why we think the claim will not work.
So people will be able to contact you. What I will do is that I will leave in the description box below a link to Malcolm's firm. Should you wish to ask his firm any questions, you can get into contact.
Yeah.
Also as well, I am going to leave a link to the CICA compensation scheme in the description box below. So if you have any questions, please do get in contact with me as well. I will leave my organisation www.daughterarise.org.uk down in the description box below. If you have any questions about this topic or just want to talk to me about things to do with maybe your experiences, you can contact me and we can arrange to have a chat. So thank you for that, Malcolm. Thank you for your time today. And I will definitely be posting your details below. And yeah, thank you guys for tuning in. Okay, take care. Bye.